A federal judge is seemingly skeptical about a lawsuit filed against the Department of Government Efficiency. 14 states are suing to restrict the department's access to sensitive data of Americans, including through the Treasury Department. They're also suing to prevent the firing of probationary federal workers, claiming it's executive overreach. But Judge Tanya Chutkan says the states have not yet established that there is imminent harm that could be avoided by restraining the department. A ruling is expected to come by the end of the day tomorrow. Let's talk about it with Chief Legal Analyst Khalif Rhodes here. What do the states need to prove here to show that there is imminent harm?
They're going to have to show that, first of all, they have an injury in fact, and that whatever happens is not something that's going to be harm. That's something that may occur in the next few days. It can't be, and as she mentioned in the hearing, it can't be something that you're pulling out of, a news report, out of something that you read off the internet. It can't be speculation. It has to be an actual injury that you can point to and say, you know what, if I'm harmed today, I'm going to receive an injury today. Not if I'm harmed today, I may have an injury down the road. I think I may potentially have an injury. I can't point to my injury. And that's kind of how she picked apart that argument. While she believes and she understood and appreciated that part of the rationale and the strategy of the administration is to kind of be sporadic and to kind of throw a number of things at you at once, making it extremely hard for the attorneys general to be able to point to a specific injury that can be imminent. But if you got to look back and say, I know Judge Chutkan was not anticipating, if we all have bingo cards, that on her list of bingo cards, at one point she'd be overseeing a case that was prosecuting the potential president of the United States. Then fast forward to now dealing with a case that deals with the implementation of one of his executive orders. I mean, if you had to pull those two things out of a hat, I can guarantee she wasn't anticipating this landing on her desk back-to-back times.
Absolutely. And after the arguments, why would the judge be leaning this way? I mean, the lawyers for the Trump administration, they claimed Elon Musk does not have the authority to make the government decisions for himself. But the judge disagreed.
Well, she doesn't buy that at one point. Let me read what she says. This is essentially a private citizen directing an organization that's not a federal agency that have access to the entire working of the federal government, fire, hire, slash contracts, terminate programs, all without, and this is the key part, without apparently any congressional oversight. And that's what the attorneys general is arguing. They're all saying that, listen, we have a process established for this. If you want to have someone that have access to these types of things, that's doing some type of government oversight, well, just bring them before Congress. Allow Congress to weigh in. And Congress can either accept or reject this nomination for this person. But what you're attempting to do here is kind of circumvent that whole congressional oversight. Because if this individual, and Elon Musk is this individual we're talking about, is overseeing and running an organization that has the power to do the things that apparently he has the power to do, the government should have an ability to oversee that. Congress should be able to have congressional hearings and say, hey, we don't like what you're doing here. You may have stepped too far. And then you're asking for access to private citizens' individual information that also should be required to have oversight. So there are a number of red flags. So you ask the question of why Judge Chutkan would hesitate, would not just do an order right there on the bench. She wants to make sure she gets it right, and then she's probably trying to figure out, well, have they made an argument to at least allow this to continue? I don't know if she'll agree to this imminent, but I think at a further hearing where you're looking for something like a longer injunction, not an emergency one, but a temporary one or a permanent one, I think they have met their standard. But for that imminent harm portion, I think that's what she's battling with, and I don't think the record preserves that to allow her to do that right now.
And this is the start of a lot of legal happenings over the next few months when it comes to a lot of these different agencies and a lot of people that are affected, that are losing their jobs or have their sensitive information that have been compromised.
And it is a really tough place to put folks in because you don't really know who's defending you. If you're an employee, that you're a civil service employee, you're supposed to have the protections. And I think for those folks that are past the probationary period, they have those. But if you're in that weird space, 1 year to 3 years, and you're still a probationary employee, well, who's defending me? Who's protecting me? And right now is these attorney generals on the state level that are filing complaints against the federal government who is fighting it. So right now, no one knows who's defending them. But in the middle is these employees, or I should say ex-employees, that are being hurt.
All right. Chief Legal Analyst Khalif Rhodes, we'll leave it there. Thank you.